Rachel Wolf and Sharon Liko both join us. And you hear Beth, quite rightly, pointing up what the defense needed to do in its closing argument. Let's talk about what they were actually able to do. And first, let me jump out to you, Sharon. Do you think you heard what you needed to hear, or more to the point, the jury heard what it needed to hear from Jim Bell in his defense on behalf of this defendant?
No, not really. It still doesn't explain why she did, why he would commit suicide. Yeah, he's in bad shape. He's definitely on the way out. But if he's got a very strong belief in God and in his faith, which is what the prosecution brought out, it seems highly unlikely that he would kill himself and not pave the way to a better life in heaven, if that's what he believes. The defense, I don't think, offered up a theory that was really believable. The stepdaughter has more of a motive than anybody else. If she was cut out of the will, then she would make the will disappear and kill her father so that he dies intestate and she inherits under the law. Yeah,
Cindy Wilkerson. And that was a big part of the case early on. In fact, prosecutors called her to the witness stand to try to dispose of that, and perhaps the defense felt they had disposed of it, but certainly that might have been a good theory of the defense. Let's go out to Rachel Wolf, who's there in Tennessee. Rachel, maybe the law in Tennessee informs the decisions that were made more than those of us who sit here in New York can do. What was your sense of Mr. Bell's closing argument? Do you think he did what he needed to do for this jury, especially keeping in mind that he hasn't got any burden here, despite what Prosecutor Richard Fisher might want to suggest in his rebuttal? The burden is not to prove that she didn't do it. The burden is for the prosecution to prove that she did. So did Bell raise enough reasonable doubt, Rachel?
Well, Jamie, in this case, it's kind of rare that the entire case is built on circumstantial evidence against this defendant. And when there is a case just on circumstantial evidence, you need a higher standard, which in this case is not only do they have to prove there was a murder, but they have to prove that this circumstantial evidence shows that there isn't any other reasonable person that could have done it. And I think that's something that Bell could have stressed more along the lines of who else could have been the perpetrator of this murder. And I don't think that he touched upon that enough. I think he spent the entire thing on the suicide aspect and didn't go into, well, if you don't believe that he did commit suicide, then this isn't the person who murdered him, and giving the jurors some options to consider in the jury room on who did it. Yeah,
it's a tough call. We've talked throughout about whether the defense should have chosen a single theory, suicide, or plan B of the stepdaughter, the biological daughter of the victim's stepdaughter, to this defendant, and they went for a little of both, and the question is whether or not either one will be enough for this jury. We're going to take a very quick break. Gives us a lot of opportunity to talk with our guests, more from Beth Karas as well. Live coverage out of Knoxville, Tennessee continues. Raynella Doessett-Leath charged with the murder of her husband. Stay with us. The Black Widow murder trial winds to a close, but did Raynella Doessett-Leath kill her husband, or did he kill himself? We are live in Tennessee. Plus, you saw foreclosure court right here yesterday. Later, my take on the foreclosure crisis. A new hour of Best Defense starts right now. This is the Best Defense. I'm Jami Floyd. Raynella Doessett-Leath is charged with the murders of her two husbands, but she's now standing trial only for the second death. Doessett-Leath says she had nothing to do with David Leath's fatal shooting. Her defense says it was probably a suicide, but if not, the grieving widow certainly, they say, was not the trigger person. Correspondent Beth Karas is at the courthouse. Beth, closing arguments all done, and the case is about to go to the jury, right?
Yes, the judge is giving some final instructions to the jury, and just seconds ago he said he's about to pick the two alternates. 8 men and 6 women sat through this trial, hearing all the evidence, not knowing which 2 of them will be the alternates. Now, he's going to pick them, then we'll know the gender composition, at least, of the jury, and maybe a little bit more. He said all 14 of them are going to be taken to lunch. After lunch, the 2 alternates will be permitted to go home, and the 12 remaining jurors will begin their deliberations. So I don't expect that deliberations will begin until at least sometime between 1 and 1:30.
And Beth, we heard from the prosecutor, the lead prosecutor, Richard Fisher, in this case, came back specially to try this one. We heard from him twice in the course of closing arguments. He made an opening close, and then he made a rebuttal closing argument. What was the main point he hammered home for this jury?
Well, you know, this being a circumstantial case, he talked about the little pieces that fit together and all point to Raynella Doessett-Leath. Her staged alibi. She did things that she had never been known to do before, like visit her mother-in-law in the hospital. She hadn't done that before in bringing flowers to her. She was lying on the lawn face down when the police arrived silently and started wailing and carrying on. Once an officer tapped her and said, you know, there's been a report of a shooting in your house, and then she was carrying on. So he says that was all staged. And he talked about the drugs in the system of Doessett-Leath, that they sedated him. He didn't have prescriptions for these. She had access to drugs, and there was evidence that there was chronic use of these drugs. She was drugging him who knows for how long, and that was causing the confusion and of course caused his treating physician, Dr. Bryan, to diagnose by process of elimination Alzheimer's, which at autopsy was determined not to be the case. He talked about how this man did not believe in cremation, did not believe in suicide, yet that is what she asserted, suicide, and what she had done to him. She burned his body and all the evidence in it as soon as she could. And he talked about the order of the shots, and the real smoking gun in this case was that the last shot fired, according to the prosecution, was fired into the mattress, and that she actually manipulated the gun in his hand to fire that last shot to get residue on his hands. It's not any surprise that she didn't have blood on her, but he did say, if this is your loving, dear spouse that you have found who committed suicide dead in bed and you're a nurse, aren't you going to do something? Check for vitals, do something, embrace him. Shouldn't she have had blood on him because she went to his aid upon finding him in bed, but she was clean of blood?
And Beth, and of course the defense had its opportunity to address the jury, and throughout there were 2 possible theories of the case: a suicide or that someone else pulled the trigger, not this defendant. It seems James Bell selected one of those for his close. Tell us more about that.
Yes, he did focus on suicide here. And he also, but he did say to the jury, and very effectively, look, if you believe it's suicide, then it's not guilty. She didn't do it. And if you believe it's homicide, then she'd have to be there. But we have accounted for her time. And he went through the timeline, at least from 9 in the morning until she calls 911 at 11:23 in the morning. And if she's not there, then she's not guilty. And if you simply don't know she's not guilty, that's not proof beyond a reasonable doubt. There may be jurors who believe this is not a suicide, that it's a homicide, but they can't put the gun in her hand. And, you know, I talk to people around the courthouse who are observing the trial, and, you know, it's really split. A lot of people think she may have done it, but they're not sure they would convict based upon this evidence. You can put the gun in her hand if you believe it's a homicide.
Yeah, and we've seen cases before, Beth. Robert Blake comes immediately to mind, where jurors said after the fact, look, I had a hunch, but the prosecution failed to put the gun in his hand. Well, let's discuss this with our guests. We have 2 terrific guests joining us today here in New York: criminal defense and family law attorney Sharon Liko, and in Knoxville, criminal defense attorney Rachel Wolf. And ladies, I want to ask you both the same question, and that is about this presumption of innocence, the burden that is on the prosecution. It's not enough, is it? And Rachel, I'll come to you first, although the law in Tennessee is the same as the law in every other state on this point. It's not enough for a juror or the jury as a whole to have a hunch that this defendant may have done it. They are required to find much more, right?
Yes, it's beyond a reasonable doubt standard. And the important thing about that is this woman's life. And yes, if this was a guessing game, I think most people would probably guess that she is the one if this was a homicide that did it. But we need such a much higher standard when someone's life is on the line.
And coming to you, Sharon, this case, and you come to us visiting, we're so pleased to have you here from Denver. This case is not like some other cases where some of those lessers that Tennessee law requires be instructed really work on the facts presented. This jury either has to find she did it or she didn't do it, or at least that the prosecution didn't prove that she did it. Some of the other theories, the lesser includeds as we call them in law, just don't make any sense, and so the jury doesn't really have an option to compromise the way they might in another case, right?
Yeah, that's true. Either the jury finds that she's guilty or not, as you say. You know, reasonable doubt doesn't mean any doubt. It doesn't mean, let me see, yeah, no. It's not a balancing like it is in a civil case. The jury has to really believe that this is really what probably happened, and there's no legitimate reason or defense that could have been put forth for the defendant. You know, juries take their deliberations very seriously, and they deliberate element by element, especially in a case like this where somebody's life is at stake. It's not a robbery, it's not an assault. They know that the repercussions for this woman are huge.